first case on our docket today is NC Enterprises LLC versus Norfolk and Western Railroad Company et al. Each party will have 15 minutes to present their argument. Helen, you may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
I would like to reserve 5 minutes.
All right, very good. The arguments are being recorded, so a couple things. Number one, when you come to the podium, first, please introduce yourself so it's clear for the record who you're here today and who you represent. Secondly, make sure you stay behind the podium as we're recording. We need you to be there so we can properly record everything. We don't lose you from the screen. And lastly, please make sure you speak loud enough so we can hear you and it picks up on the recording. We've read your briefs and are ready to proceed whenever you are, so you may proceed, Counsel.
Thank you, Your Honor. Good morning. May it please the court. My name is Nicholas Bartlett of the law firm Eastman & Smith out of Toledo, and we represent the appellant Norfolk Southern in this matter. This is an adverse possession case where below the trial court erred by granting summary judgment in favor of the appellee NC Enterprises. The trial court erred, I think, in two respects which are interrelated. One, it failed to analyze the specific uses engaged by the appellee, and in failing to do so, failed to exclude 2 years of de minimis lawn maintenance activities at the beginning of the adverse possession period, improperly making NC Enterprises claim for it. NC Enterprises purchased its property in December of 1997. Adjacent to that property is 2 small parcels owned by the appellant Norfolk Southern. In early 1998 through 2000, the appellee NC Enterprises engaged in mowing and weeding and trimming and the like until September of 2000 when it placed a chain link fence on the property. During NC Enterprises' occupation of Norfolk Southern's property, Norfolk Southern listed the property for sale at various points through the years, and it also regularly paid local property taxes from 1998 to date. Upon placing a for sale sign on the property by Norfolk Southern, appellee engaged counsel and sent correspondence to Norfolk Southern making a claim of ownership to the property, which claim Norfolk Southern disputed on July 22nd, 2020. Accordingly, any adverse use had to have begun on or before July 22nd, 1999 in order for NC Enterprises to be successful in its claim. And here that just did not happen. Adverse possession as a matter of law in Ohio is disfavored, and the elements are rigorous and the standards stringent because it results in a titled property owner forfeiting his right to his property. Here the trial court erred by tacking on earlier de minimis landscaping activity to make NC Enterprises claim. But this court in Monteith versus Twin Falls United Methodist Church and the Ohio Supreme Court in Grace v. Coe engaged in the exact analysis that the trial court below refused to engage in. In Monteith, this court analyzed the specific uses engaged in by the adverse possessor, beginning in 1946, for example, when it purchased its property and began building a foundation, planting pine seedlings, spraying and harvesting apple and cherry trees, building a pig pen, maintaining and constructing a garden, and other uses including a shed and using the property as a Girl Scout camping site. This court in Monteith determined that legal notice to start a claim for adverse possession did not begin until the pig pen was built in 1950. Similarly, in Grace v. Coke, the Ohio Supreme Court analyzed certain uses engaged in by the adverse possessor, including mowing of grass, parking of cars, having children play on the disputed property, placing firewood and oil drums. And the court found that those, as a matter of law, those uses did not constitute adverse possession, but did note later in the opinion that the adverse possessors did place a carport and a tree on the property, but those improvements were made long after the crucial year in which such uses had to have begun in order to maintain a successful claim for adverse possession. Both of those cases involved the court specifically analyzing the uses engaged in by the adverse possessor to determine when the 21-year period begins to run. And here the trial court failed because it did not exclude the 2 years of de minimis lawn maintenance activities beginning in 1998 until September of 2000, which are insufficient as a matter of law to constitute adverse possession to begin with. Accordingly, NC Enterprises' claim could not have begun at the earliest until September of 2000 when it constructed a chain link fence. The fence was placed after the critical date of July 22nd, 1999, and the trial court erred in granting judgment in NC Enterprises' favor.
In your view of this kind of, is the brief talk, the mere maintenance standard of this, what of the elements does that fail in according to the case law? Is it not open in the view of the court? Is it not notorious? How does it fail?
I think from the opinions, I believe it's an open and notorious. I don't think it's, from the opinions, the courts state that it's not, it doesn't provide notice in law to the true owner that their dominions have been invaded. So I believe it applies to that open and notorious standard. If there are no other questions, I'll reserve the rest of my time.
Do you have any comments on the finality issue? That is still before the court today. It was taken under advisement for this panel.
Can you, I apologize, can you repeat?
There was an argument, there was an argument on whether or not the decision for the trial court was the final order in this particular case. And I think it didn't have parcel numbers, perhaps it didn't have a legal description. Do you have any comment upon that?
Upon the legal description or the finality?
Final order.
I believe it was a final order because my understanding of the complaint was that NC Enterprises pled a claim for adverse possession and quiet title, arguing that it had acquired the property by adverse possession, and in the alternative made an unjust enrichment claim. So when the trial court granted judgment in NC Enterprises' favor on the adverse possession claim, it didn't need to address the alternative theory of relief pled by NC Enterprises.
Okay. Thank you.
Thank you.
And you'll have your full 5 minutes for rebuttal.
Thank you, Your Honor.
May I please the court? Counsel, my name is Frank Maskai. I'm here on behalf of the appellee NC Enterprises, LLC. First of all, Your Honor, to address the final order issue, it is our belief that the trial court did not issue a final order given that there was no remedy actually awarded. The court did not indicate that we are entitled to quiet title for the 1.4 acres of property. So the court granted summary judgment as to the adverse possession issue and that we are entitled to relief, but the specific relief, the court did not issue an order regarding that. As far as the court's determination on the motion for summary judgment, I think the case law says that there are no particular set of facts or no bright line rule that will govern in every single case, and that you have to take the activities as a whole, and that real estate is unique and you have to look at that situation. Well, in this case, this is not a field that is in some farmland far off the beaten path. This is a strip of land that borders a road. There are other businesses in the area. It is an industrial area. It's Monroe Falls Avenue. But in this case, we have my client's property who has maintained not only the structure, but the adjoining grass, and then this 1.4 acres is what is contiguous to my client's property, and then there is another business directly across from that. There is no dispute that from at least 1998 until 2021, Norfolk and Southern at no time viewed the property, went to the property, inspected the property, had anybody care for the property in any way. Had they done that, they would have seen, started in 1998, that this wasn't simply an industrial field with a bunch of weeds. They would have seen from 1998 up until 2021 that the property was not only just cut, but was very well cared for. The bringing in of mulch, the planting of trees, the removal of trees, the edging of the grass, weeding of the grass. They made it look essentially like a park that existed there. Had anyone from the railroad seen that property, they would have understood this, somebody is caring for this property, and it is not us. that is the kind of the unique property in question in the analysis that I think the court needs to do, and the other courts have done in coming to that issue. Items such as caring for the lawn, mowing, mulching, cleanups, those can all be evidence of open and continuous, which it was in this case. And it, in certain factual scenarios, can be enough. And then during that period of time, and you'll see there are diagrams attached to the motions for summary judgment, not only was this property well cared for by mulching, plantings, trimmings of trees, but there also were floods that occurred caused by this property, the property at issue. My client took it upon himself to finally try to remedy that issue. The Norfolk and Southern showed no interest, or as far as we know, didn't even know that the property they allegedly owned was flooding the neighboring properties. Nobody is disputing after the fence was erected on the front of the property, the gate was installed, my client did extensive repairs to a creek in the rear end of the property, put in stone, put in piping, put in culvert pipes. True, that all occurred less than 21 years prior to us putting Norfolk Southern on notice, but I don't believe you can just throw out the 2 years of what they describe as de minimis maintenance of the property. There was far more than simply cutting the grass.
You agree with their premise that if the trial court had found this was de minimis for a year or two, the time wouldn't have started running until 2020 or something, 2000 or some other day? But you're telling me it wasn't de minimis, it was from day one, it was enough to put them on notice.
I agree, Your Honor,
But
yes.
would you agree that, would you disagree with their analysis that if the court had found it was de minimis until 2000, then it would not have been open and notorious at that point, or not 21 years?
Sure, if the court determined that the installation of the fence was the first act that starts the 21-year clock, yes, it's going to be less than the 21 years, and that would not be sufficient time.
There was no, as I recall from this matter, there were summary judgment filed on both sides.
Correct.
So there was no real dispute about what the facts were, just the law applied to those facts. Is that fair?
That is true, Your Honor. At that point in time, we agreed to submit it by affidavit and by deposition. Now, I guess if the court determined, well, it's not enough that you can determine as a matter of law, the court could, I guess, determine that there are genuine issues of material fact and there wasn't enough there. But the parties had agreed at that point to submit it based on the facts that we believe were developed. And based upon, I think most importantly in this case also are the responses to the discovery request propounded upon Norfolk Southern. I mean, they, as throughout, and I think it's true, they had no knowledge, they had nobody there, they knew nothing of what was going on at this property. Had someone driven down that street at any time, they would have seen that this wasn't simply keeping the weeds at 3 feet. It was in the fall removing the leaves, in the spring putting down mulch, plantings, putting in new shrubs, removing shrubs, trimming trees, and all of those things occurred during that 2-year period of time that they questioned. Mrs. Geary, you'll see in this case, was probably one of the most meticulous bookkeepers you'll ever meet. She has every single invoice going back to 1998 to the present. I've never been involved in a case where somebody has been that meticulous and kept records so meticulously like that. You'll see from essentially the time that my client acquired this property up until the present, every single record of every activity is noted. Based upon that, we ask that you would confirm the decision of the trial court in granting the summary judgment in favor of my client, unless you have any questions.
Yeah, I have a question. I want to follow up with Judge Stevenson's question, and that is, basically, they're alleging that the 2 years was tacked on in order to make the 21 years of adverse possession. And as Judge Stevenson said, I understand that you're arguing that the first 2 years from 1998 to 2000 were not de minimis use of the property, but it's much more than de minimis. But let's say it was de minimis. I'm not sure you exactly answered his question. Not that the trial court found that the fence was the first act of adverse possession, but let's say the trial court, did not find that, but just said, well, they started using the property in 1998, and so does that still count? In other words, are they correct that you really have to go in here and pick apart, when the actual adverse possession started, and you can't just use whenever they start using the property?
I agree, Your Honor, it's not just whenever they start using the property. You have to analyze what they did to use the property. And I think using, again, the unique location of this property, the manner in which we were using it during that first 2 years is not de minimis. That, in fact, it did start what I'll call the adverse possession clock at that time. And I agree that if the clock didn't start at that time, but in fact started, let's say, when the fence was put up, it would not have been 21 years up until the time that they were put on notice of our claim. I hope that answers your question as my position.
Yes, I think we're just trying to I am, at least, and I don't want to speak for the rest of the panel, but we have to agree on what the law is to begin with in order to, so I think you two are in agreement on what the law is, just whether the facts meet that particular.
Right, I would tend to agree with that. You need 21 years of open, obvious, notorious. I think we met that by the time we started maintaining that property in 1998.
On the final appellable order issue, do you think that there is any claim that was complete whatsoever?
Your Honor, the court granted summary judgment, I would say, on the issue of liability, or they did grant summary judgment in our favor, saying that we did adversely possess that property and that we are entitled to it. But the court did not specifically, I think the court should issue an order as to what exactly are we entitled to. Again, there are two parcels here. One was for, I think, either 0.4 acres, another one was 1.04. I don't think there's any dispute that both of them fell within the court's ruling, but I think in order to get quiet title, the court would need to issue some order to do that. Now, whether the court can issue that order subsequent to the appeal, should the court affirm our decision, or the trial court's decision, I guess that is what we would do, or how that would be handled.
And it's clear, I think, from what you're requesting at least, that you're requesting these two parcels specifically. They're the third larger parcel. You're not requesting any part of that.
Correct, Your
It's
Honor.
just these two particular parcels.
Yes,
So we can
yes.
identify from the order exactly what you're requesting.
That is correct. Yes. Okay, thank you very much for your time.
And again, Counsel, you'll have your 5 minutes.
Thank you, Your Honor. Briefly, I will address a few things. On the finality issue, I think that this court can reverse the summary judgment, the grant of summary judgment by the trial court. I think the trial court's grant of summary judgment effectively determined the issue by granting adverse possession to the appellee, finding that it had met its burden. Counsel argues that the evidence was undisputed, that nobody from Norfolk Southern ever visited the property. Had they visited the property, they quote, would have seen the improvements made. I do want to clarify that Norfolk Southern is just not aware that any representative had visited the property. It's not clear whether or not anyone did, but for purposes of this appeal, it's as if no one had visited the property. But even still, the law of adverse possession is clear that the adverse possessor must engage in some use that is noticed in law to the true owner, not in fact, but in law. Meaning that it doesn't matter whether or not Norfolk Southern actually saw the improvements made or didn't see them. And then finally, opposing counsel mentions that de minimis lawn maintenance, or lawn maintenance in general, can be relevant to whether a use satisfies adverse possession. But the cases that Applee cited in their brief all involve structures that existed for 21 years. Here, they did some drainage activity, installed riprap and fence. Those did not exist for more than 21 years. And I think where that standard comes into play, whether or not lawn maintenance is relevant to establish adverse possession, if, for example, you think of a drainage dry well or a ditch, you're not continuously using or occupying those. They're there for drainage purposes, but if you maintain the land around it, that is relevant to the continuous nature of the improvement. So I think that is a clear distinction here, where no improvements were made at the beginning of NC Enterprises' occupation of Norfolk Southern's property from 1998 until September of 2000, when they put up the chain link fence. And it's at that point that the adverse possession, the 21-year period, would begin to run.
Is your assignment, and to review that, are you saying that A, both the trial court erred in granting summary judgment to the appellate in this case, and B, they should have granted it to your client?
Correct. Our brief had an assignment of error that the trial court erred in granting summary judgment, and the relief we requested is that this court instead grant judgment in favor of Norfolk Southern, which it may do as this is a de novo review. And we would request, of course, if there are no further questions, we do request that the court grant judgment, the court reverse the trial court's judgment and instead grant judgment in favor of Norfolk Southern. Thank you.
Thank you. And thank you both for presentations today.
Thank you, Your Honor.
The court will take the matter under advisement, will issue a decision in due course. The clerk of court will mail that decision to you when it comes out, and it will all be posted on the Ohio Supreme Court website.
Thank you, Your Honor.
Thank you.